Court does call the case of People versus Jenny Lou.
Good morning, this is Public Defender Lauren Kearney on behalf of Ms. Lou. Ms. Lou, please state your name for the record.
Jenny Lou.
Before we even hear the first name called, understand what kind of courtroom this is. This is not a single dramatic trial with one verdict that changes everything in an instant. This is a sentencing docket, a rapid-fire window into dozens of lives intersecting with the justice system in real time. Some of these defendants are here for the final chapter, others are about to open a brand new one, and every decision you're about to hear carries weight that extends far beyond these four walls. Today, you'll see mercy, accountability, frustration, and something judges rarely talk about openly: fatigue. Fatigue from seeing the same people come back again and again. Fatigue from balancing public safety with second chances. And fatigue from knowing that sometimes the system helps, and sometimes it just contains damage. Our judge today is Judge Simpson, and if you've watched enough courtrooms, you already know the type. Calm, direct, occasionally warm, but never careless. He listens, he remembers names, and when he says something offhandedly, it usually carries more meaning than it sounds. We'll start with Jenny Lou, a woman finishing a long prison journey and standing at the edge of release. Then we move immediately into the opposite problem: a defendant who doesn't show up at all. From there, we'll see restitution negotiations, probation conditions, missed chances, second chances, and one of the most emotionally layered courtroom conversations you'll ever hear, involving family, addiction, and a judge who refuses to let honesty slide past without meaning. As you watch, ask yourself this: is the court here to punish, to rehabilitate, or simply to manage consequences as best it can? Because by the end of this docket, you may realize the answer is all three, and none of them are clean.
Okay, there you are. Okay, go ahead.
Your Honor, today's the date and time set for sentencing. I did review the recommendation with Ms. Lou, and we ask that you adopt it. This is the last case that Ms. Lou has pending before this court. She is expected to be released in April after serving, I believe, 5 years in prison. While in prison, she's done a lot to improve herself and make her time there productive, engaging in things like mental health therapy and things like that. I do again ask that you adopt it, and I do wish Ms. Lou luck on whatever comes next for her.
Ms. Lou, is there anything you'd like to say before I impose sentence?
No, Your Honor.
All right. Sentence of the court: statutory fees of $125, 365 days in jail, credit for 365 served. And I would join counsel. Ms. Lou, we're going to miss you. I don't know how many times I've seen you before. All right.
I know, right? It's been a journey.
Once you're released, I wish you all of the best. Right.
Thank you. I appreciate you.
All right. Take care.
You too, Your Honor.
Court does call the case of the People versus Cameron Reeves.
Assistant Public Defender Natalie Kay on behalf of Mr. Reeves, Your Honor, who I do not believe is present unless he is on Zoom.
I don't see.
Your Honor, I'm not sure where he is, and I unfortunately don't have an explanation for his failure to appear. I did make numerous attempts to try to reach him prior to today's sentencing. It is my understanding he did complete the interview, and there was a PSI completed. I also did as well with his mother. Unfortunately, I do not have an explanation for his failure to appear. Requesting his record.
And Teresa Claire on behalf of Probation. Your Honor, Mr. Reeves did complete the PSI. However, Mr. Reeves does have a history of not appearing before this court. Probation would request a
Bench warrant will issue for defendant's failure to appear. Bond will be set amount of $5,000. I'll give a 10% privilege. There having been previous warrants, this warrant will issue immediately.
And just like that, the tone flips completely. Cameron Reeves doesn't speak, he doesn't explain, he doesn't even appear, and in court, absence is not neutral. It's defiance by default. From a legal standpoint, this is textbook. Failure to appear, prior history of non-appearance, a completed PSI that now works against him instead of for him. Probation requests a bench warrant, the judge agrees. Bond is set at $5,000 with a 10% provision, and the warrant issues immediately. No delay, no warning. What's important here is why the judge moves so fast. This isn't punishment, it's control. Courts operate on predictability. When a defendant breaks that predictability, the response has to be decisive or the entire system loses authority. Now here's the engagement question. If you were the judge, would you see this as irresponsibility or intentional avoidance? Because either way, the consequence is the same. And when Cameron Reeves is picked up, this missed hearing will follow him into every future decision.
Court does call the case of the people versus Julian Tehran.
Is that Tabron, Your Honor?
Yes, Tehran. Tabron, I'm sorry.
Good morning. Assistant Public Defender Lauren Perny on behalf of Mr. Tabron. Mr. Tabron, please state your name for the record. Say it again, Mr. Tabron. You sound really faint to us.
Here, let me try again. Can you hear me now?
Yes, that's much better, sir.
Okay, Julian Tabron.
Thank you.
Your Honor, today is the date and time set for sentencing. We did the pre-sentence report and do not have any material changes or deletions. We do ask that you adopt the sentence recommendation regarding the restitution. My client did inform me he's planning on coming up. I did inform him the restitution needs to be paid in person in cash. He is planning on coming up to the court to pay $330 today in person. As for the rest, he is planning on paying in installments if the court allows.
Tabron, anything you want to say before I impose sentence?
I just like to echo Lauren said. I'm be coming to the court to make a payment. So I'd hope I'd just receive probation, and I'm happy to comply with making payments for the restitution.
This is where courtroom sentencing turns into financial reality. Julian Tehran isn't arguing guilt. He's negotiating feasibility. And that distinction matters. The court isn't deciding whether he owes restitution. That's already settled. The real issue is whether his plan sounds realistic enough to trust. Restitution isn't symbolic. It's not a fine paid to the state. It's money owed directly to a victim, in this case, a business. When the judge presses him on how he's going to pay, it's not to intimidate him, it's to assess credibility. Notice how specific this gets. Cash payment today, monthly installments, employment verification, no alcohol, no drugs, random testing, theft class, community service, no contact with the victim location. This is probation as structure, not punishment alone. A but supervision designed to prevent repetition. Here's the question viewers should be asking. Is probation actually a second chance? Or is it just delayed incarceration? Because for Julian, one missed payment or one bad decision flips everything instantly.
That's it.
On count 4, it's the larceny 200 to 1,000. It's sentence of the court, 24 months probation, $555 fines and court costs, $720 probation oversight fees, and $6,030 restitution to Tetra Tech payable through the court. How are you intending on paying that, sir?
I spoke with the probation officer, and I was going to make monthly payments of about $330. I forgot the exact number, but it's around that ballpark per month. And I have a job.
So you're going to pay you're going to come up today and pay how much?
I believe about $330 it is.
All right.
Redoing.
I'll put you're going to pay $330 today. That is going to be paid in cash. That goes to the restitution. And then I will indicate a payment plan as arranged by probation, right, for that amount. There's to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You are to complete a theft class. You're to do that within the next 90 days. You are to complete 25 hours of community service as directed by probation. There is no going to Tetra Tech on Oak Valley Drive in Ann Arbor, Michigan. You're to maintain employment with proof to probation. I'll order 365 days in jail. Credit 2, the balance is suspended. On count 5, 24 months probation. You're to pay $455 fines and court costs. That will be wrapped into your payment plan through probation. You're to comply with all terms that I set forth in count 4. I'll order 90 days in jail. Credit 2, the balance is suspended. Thank you, sir.
Thank you, Your Honor.
What we just witnessed is something most people underestimate: probation stacking. Julian didn't just receive one probation term, he received multiple counts layered together, each with suspended jail time hanging overhead. That suspended time is leverage. It's the court saying, we're trusting you, but we're watching. Legally, this is efficient. Practically, it's stressful. Every condition compounds pressure. Every obligation competes with real life. Work, transportation, money, mental health. The court sees compliance as choice. Defendants often experience it as survival math. Engagement question here. Do you think people fail probation because they don't care, or because the structure itself becomes overwhelming? Because this case shows how quickly accountability can turn into overload.
Court does call the case People versus Justin Tittle.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Tittle, who appears via Zoom. Sir, can you please unmute and state your name for the court?
Justin Tittle.
Thank you, Your Honor. Today's the date and time set for sentencing. I have had the opportunity to review the PSI with Mr. Tittle, and we have no material changes or corrections. And as to the sentencing recommendation, would be respectfully requesting this court to adopt it.
All right, Mr. Tittle, anything you want to say before I impose sentence?
Sorry for the inconvenience and God bless.
All right. Sentence of the court, $125 statutory fee, 90 days in jail, credit 90 served. You're all set. Good luck to you, sir.
Thank you. You'll have a good day.
Yes, sir. Thank you, Your Honor.
Court calls the case People versus Frederick Warden.
Public Defender Lauren Perny on behalf of Mr. Warden. You're coming in person. Please state your name for the record.
Frederick James Ward, second.
Your Honor, today is the date and time set for sentencing. We did review the sentence recommendation. Believe it to be fair. We do ask that you adopt that recommendation.
Sir, is there anything you'd like to tell the court before I impose sentence?
No, sir.
This is where Judge Simpson shows his philosophy clearly. He explicitly acknowledges that this offense is not a serious misdemeanor, and then explains why he's departing from a non-probationary presumption anyway. That explanation matters. Judges are required to justify departures, and here, the justification is rehabilitation, alcohol screening, intensive outpatient treatment, 12-step meetings, monitoring compliance. This isn't leniency, it's intervention with teeth. Financially, the numbers stack quickly. Fines, court costs, recovery fees, probation oversight. Even before treatment begins, the defendant is financially underwater. The judge mitigates that with a payment plan, but the burden remains real. Engagement question. Do you think treatment should replace jail or accompany it? Because this sentence tries to do both. And whether that balance works depends entirely on follow-through.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, believes there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening and assessment identifies the benefit of intensive outpatient treatment and attendance at 12-step meetings. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to prevent recidivism, promote change, and to monitor compliance of recommended treatment. This is therefore the sentence of the court. I'll place you on probation for a period of 18 months. You're to pay $855 fines and court costs, $100 prosecution recovery costs, $100 police agency recovery costs, $540 probation oversight fees. When can you get that paid, sir?
I'd like to make payments if possible. I have 200 on me today.
You have 200 today?
Yes, sir.
Thank you for that. So pay 200 today, and then the balance is arranged by probation through a payment plan.
Okay.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete an IOP program, including all recommended aftercare. The status reports to probation. You are to attend 2 AANA meetings per week with monthly verification to probation. You're to provide proof of victims impact panel attendance to probation. I'll order 93 days in jail, credit 3. The balance is suspended.
Yes, sir.
All right, thank you. Court does call the case of the People versus Christopher Fair.
Assistant Public Defender Natalie Pate on behalf of Mr. Fair, Your Honor, who I unfortunately do not believe is present today. I did leave voicemails at both numbers. Mr. Fair, unfortunately, I did not hear back. And it is my understanding there is unfortunately also an outstanding bench warrant out of 14A2. Outside of that, Your Honor, I do not have a further explanation for his failure to appear and respectfully request an adjournment for the record.
And Teresa Blair on behalf of probation, Your Honor, this is a review hearing before the court. However, Mr. Fair is non-compliant with the terms ordered by this court. And given that he is also not here and has other bench warrants out there, probation would request a bench warrant in this case.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $15,000. I will give a 10% privilege on that. That warrant, however, will issue immediately given previous warrant.
This is the second failure to appear moment in this docket, and it matters that it's happening again. Christopher Fair isn't just absent. He's non-compliant, already carrying outstanding warrants, and now missing a review hearing that existed to give him a chance to demonstrate progress. Review hearings are opportunities. They're check-ins designed to reward compliance or correct course early. When someone skips that moment, the court's patience collapses quickly. Legally, the response is predictable but severe. A bench warrant, $15,000 bond, 10% provision, immediate issuance. That number isn't random. Bond amounts scale with perceived flight risk and history. This court is signaling clearly that Christopher Fair is no longer trusted to return voluntarily. Like audience question here. At what point does the court stop offering chances when and start prioritizing containment? Because this case shows exactly where that line gets drawn.
Court does call the case People versus Kenneth Hoffman.
Claire on behalf of Mr. Hoffman was scheduled before the court today for a review hearing on a prosecutor deferred sentence. He did complete all terms ordered by the court, and I did wait for appearance. Probation is recommending that the court dismiss the case pursuant to the prosecutor deferred and discharge from probation with improvement.
Hearing no objection, so ordered. Court does call the case People versus James Johnson.
This is the show cause, correct, Your Honor?
I haven't said a word.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Johnson, who is in custody, and explains why I was unable to reach you on the phone, sir, for your show cause hearing. So I do apologize for that. Please state your name for the record, sir.
James Johnson.
He spent a lot of time there. But that's
I'm off the probation after this.
I'm just saying.
Given that Mr. Johnson's in custody and this is a show cause, Your Honor, I'd ask for an adjournment.
Well, he's being held on something else.
Yes, he might not be released until sometime like that.
Yeah, I got like 30 days, so I'm gone.
Another 30 days.
Yeah, like 34. I took a plea to cancel my probation and all that off of violation. So after this, I'll be done with everything.
And this is regarding fines and costs and everything.
Yes, Your Honor. It looks like the balance is 674.
All right. Why don't you give me, if he's got 30, then give me 2 months out.
2 months out now would be August 13th.
August 13th. I'll adjourn this to August 13th, 2025, 9 a.m.
This exchange with James Johnson feels casual, but it's layered. On the surface, it's a scheduling adjustment. He's in custody on another matter. He owes money. The judge pushes the date out 2 months. Simple. But listen closely to the tone. Judge Simpson jokes, challenges, and then says something crucial. I remember everything. That's not humor. It's accountability disguised as rapport. Judges build credibility through memory. When defendants realize they're remembered, excuses lose power, promises gain weight. Audience engagement question. Do you think informal courtroom moments like this help defendants take responsibility? Or make them take the process less seriously? Because this judge walks that line carefully, using familiarity without surrendering authority.
See you then.
He's not going to show up. I'm at the bench. Might as well do that now, right?
No.
Right?
He'll be here.
I'll be
No,
here, man.
I know you. You just don't.
Hey, I'm changing, man.
Are you?
Here. So I'll be here for sure.
Make a note of that.
Your
All right,
Honor.
guys.
Thank you, sir.
Take care of yourself. Court calls the case People versus William Layman. Or Layman.
Good morning, still morning. Assistant Public Defender Lauren Perry on behalf of Mr. Lanham. Mr. Lanham, please state your name for the record.
Morning, Your Honor. Mr. William Lanham.
Your Honor, we are here for, I guess, a review date. At our last hearing, which was Mr. Lanham's sentencing hearing, you held the potential 4 days in abeyance for Mr. Lanham to have a serious and frank conversation with his parents, specifically his mother, about the events that have taken place over the last, I guess, year and a half. His parents are here with him again this morning. I did have a conversation with Mr. Lanham yesterday that he did have that conversation with his mother, and that it went very well. I did also speak with him regarding his probation. He says there's been no issues on probation. He's been complying with what he needs to do.
This is where the docket shifts from procedural to deeply human. William Lamb's case isn't about fines or missed dates. It's about introspection. The court isn't measuring compliance alone. It's measuring growth. And the judge does something rare. He asks about a conversation with a parent. That tells you something important. Courts often see behavior before they see insight. Here, Judge Simpson wants proof that reflection occurred, not just obedience. Probation compliance is expected. Emotional honesty is not. And that's why this case slows down. Question for viewers: should courts care about emotional accountability or only legal compliance? Because this hearing suggests Judge Simpson believes the two are inseparable.
So I would ask that, I don't know how the court wants to do it. I guess I would ask maybe whole I guess, the full amount is the full amount of time is hanging over his head if he violates his probation. So I would ask that the court just set a regular probation review hearing out a few months.
And Teresa Claire on behalf of probation. Your Honor, probation recommended the additional 4 days because they are statutory with an OWIs.
Yes. How'd the conversation go?
Up and down. Truthful though. Truthful, Your Honor. I was really just, at the time, I was really just emotional. Sad, a bit angry about, state of the world and things going on, per se, in-house. Which is not a good thing to be mixing with alcohol at all. And yeah, I was forward about that. I have changed my ways. I've been sober since that date. I have a production company. We've been flourishing. We have a short series going into a film festival next weekend in Oklahoma City. I have a wedding project that I'm working on, a graduation project that I'm working on as well. I'm a very powerful asset to my team in the creativity, as well as working at the restaurant at the Gandy Dancer too. Still working with my community as well.
What?
Sorry, still working with my community as well.
So when you sat down and you were honest with Mom, what was her reaction in your mind?
In my eye? She said, I can't worry about those type of things. I shouldn't worry about those type of things. But, I'm an artist and I absorb things in my environment and that are happening around me. But I just need to channel them in a more responsible way.
And why do you think I did what I did?
First and foremost, out of respect for my mother.
Oh, yeah.
To shine a bit of light on me and have me reflect personally about what's going on with me inside, and how that can dramatically affect my environment and the people that I care about on the outside as well.
This moment is raw, and the judge knows it. William Lamb isn't minimizing. He isn't deflecting. He's naming alcohol, emotional instability, and responsibility. And Judge Simpson doesn't interrupt. He lets the silence work. Legally, none of this is required. Emotion doesn't reduce sentencing guidelines, but psychologically, it informs risk assessment. Someone who understands why they acted is far less likely to repeat it. Audience question: do you believe self-awareness should influence sentencing decisions? Because in this courtroom, it clearly does.
And sometimes in life, if you're fortunate enough, when you don't have anything else to hang on to, it's going to be that woman that'll be there for you. Right?
Yeah.
And in that respect, you sort of owe her everything in terms of who you are.
Yeah.
Because no matter the reality, I don't know your mom, but I just have to think that no matter what you tell her, no matter what it is, she never stops loving you. Right?
This is true, Your Honor. This is true. And it's a blessing, to be honest.
Oh, it's a big blessing. Because no matter what people are around you and who's around you, You don't have many like that just really have unconditional love for you, right? And like I said, I don't know your mom, but I just had a feeling that she's that type of person. She was owed the truth, and you owed it to her.
Definitely, Your Honor.
And at the end of the whole conversation and everything, she didn't say, "I don't love you anymore," did she? Did she say that to you?
No, Your Honor. No,
In
she
fact,
did
it was kind of probably the opposite, right?
Yes, it was.
And I'll tell you something about parents. When a kid, no matter how old you think you are, because you ain't all that old, but when your kid comes to you and tells you something, you never think that you could love them more. But when they show that confidence in you to come to you and tell you, you love them even more than you did before, if that's possible.
It's eye-opening.
That was part of the reason I did it. The other part of the reason is, how old are you?
32.
Yeah. And you go through all of this stuff, and I guess as they say in the old days, you just thought you were all grown, right? No, go ahead and answer me. You just thought you were all grown.
Not necessarily. Forever a student, Your Honor.
Yeah, I know, but you're also forever her child,
True.
right?
Very true.
And you just thought you didn't have to say anything because I'm grown.
Yeah.
Yeah.
Yes, Your Honor. That is completely true. Didn't want to burden them either.
You know, that's a nice thought, but you burdened her for 32 years. So what's right? Right?
Yeah. I made her laugh though. You know, I did
What?
good jokes in there. I made her laugh.
Made her laugh?
Yeah, I made her laugh. Good holidays, good birthdays,
See?
good family events, good family dinners.
Council approach. Along with probation. What I'm gonna do is I'm gonna pass this matter, and I may not call it up until the next block.
This pause is strategic. By passing the matter, the judge isn't punishing William Lamb. He's reinforcing gravity. Delay creates reflection. It prevents emotional momentum from turning into impulsive rulings. This is judicial restraint in action, and it's rare. The court acknowledges parents, family presence, and vulnerability, but refuses to rush closure. Viewer engagement question: would you prefer immediate decisions or thoughtful pauses like this? Because justice rushed is often justice regretted.
Okay, but your counsel will explain why I'm gonna do that.
Yes, sir.
Okay?
Thank you, Your Honor.
All right, thank you. Dad, sir, I did not mean to ignore you. All right? No, I really didn't, and I appreciate you being here. I did not mean to ignore you. I'll be honest with you, I like moms better. Yeah. All right, but I didn't. Okay, all right. All right, thank you. I'll pass this matter, and Ms. Perrine will talk to him in a moment. Thank you. Thank you. Court calls the case, People versus Caitlin Morgan.
Morning, Assistant Public Defender Lauren Penny on behalf of Miss Morgan. Your Honor, can we approach on this case again? I'm sorry.
You just talked to me. Come on. All right, on this matter, record should reflect we've had a rather lengthy bench conference in this case. There is a jail recommendation, and I'll just put it this way, which counsel is asking probation and the court to reconsider that recommendation. There may be additional information that needs to be provided to probation for their assessment as well as the court's assessment. I will give them that opportunity. I'll adjourn this matter out 1 week, although my next sentencing day is 2 weeks out, but I'll do 1 week out to June 18th, 2025. I'll set that at, let me set it at 9 or a different time.
10, that's all right.
Okay, well, yeah, I'll set it at 10. At 10 a.m. All right, and that's a special time for sentencing in this matter, and then we can take a look at everything and potentially reconsider the jail recommendation. All right,
Thank you for the consideration, Your Honor.
thank you.
We're not sleeping out. I'll be back next week. I love you.
Court does call the case People versus Amy Avey.
Hello? Hello?
Assistant Public Defender Natalie Pace is here. We have Miss Avey. Ma'am, can you please unmute the record?
Amy Marie Avey.
Is this?
Thank you, Your Honor. I believe this is a show cause, Your Honor, and I do believe there still is a balance. Miss Avey may be able to give an explanation about when she can start making payments on these files.
All right.
Yes.
Miss Avey?
Yes, hello, sir. I am on a fixed income. I can pay, $50 a month. I mean, I only get $967.
Gotcha. All right, why don't I do this? You have two files here. And so what I will indicate is in each file, defendant to pay $25 per month. Okay. And that'll begin in July.
Okay.
And that way we'll take
that,
care of it.
is that 50 total or 25 for both of them?
That's 50 total.
This exchange with Amy A. is one of the most quietly important moments in the entire docket. Fixed income, less than $1,000 a month. The judge doesn't lecture, he doesn't threaten, he recalculates. Legally, courts can enforce payment, but they also must consider ability. Here, Judge Simpson balances enforcement with reality. $25 per file, $50 total, structured, manageable, humane. Engagement question, should courts adjust financial penalties based on income? Or should everyone pay the same price? Because this decision answers that question clearly.
Okay.
So you're just
All right.
paying 25 on each of these cases, okay?
Okay. Yes, sir.
All right, we'll do it that way.
Okay. Thank you, sir.
Thank you.
Thank you, Miss Avey. Thank you, Your Honor.
Can I leave?
Yes, ma'am, you can.
Okay. Thank you.
You're welcome.
Have a good day.
You too. Court calls the case People versus Brendan Williams.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Williams. Mr. Williams, please state your name for the record.
Brendan John Williams.
Your Honor, today is the date and time set for sentencing. We did review the pre-sentence report and we do ask that you adopt it. I also reviewed we reviewed the pre-sentence report. We don't have any changes. We did review the recommendation as well, and we ask that you adopt that recommendation.
And Teresa Clare on behalf of probation, Your Honor, the victims in this case, Donna and John Juggling are present. I know that Donna would like to address the court. She would like the court to consider changing the no contact to no non-consensual contact.
This is the moment the entire courtroom changes. Up until now, we've been talking about money, compliance, and procedure. But when a victim, especially a family member, asks for contact instead of distance, the court has to slow down and listen carefully. No contact orders exist to protect. They're blunt instruments designed for safety, not nuance. And when the protected party asks the court to loosen that protection, the judge's job becomes far more complicated. Legally, Judge Simpson cannot simply agree because it sounds compassionate. He has to determine whether contact creates risk, not just emotional risk, but legal risk. Because if something goes wrong later, this decision comes back to him. Audience question: if you were the judge, would you prioritize safety through distance or healing through connection? Because this case forces that exact choice.
She is his grandmother. And there are also, his aunt is also present and a family friend that would also like to address the court, if the court would allow them to.
All right. If you'll have a seat and I'll hear from whoever wants to say something to the court.
Okay, sure. Okay.
Good morning.
Good morning.
All right. Can you first state your name and then you can tell me whatever you want to tell?
Donna Marie Jungling.
Okay, go ahead.
I'm Brendan's grandma. And I would like you to really consider giving us contact. My grandson means a lot to me. I have 8 grandchildren. He has a special place in my heart, though, because he has struggled so much to get where he is today. And even though he's in trouble, he's a good kid. We miss him terribly, at least, and me more than anything. I don't have any fears of him in any way, shape, or form. He is more helpful to me than anything. If this contact order stays in place, he's not going to be able to go back to work. We work together. We work at the same company, often working at the same sites. Brendan just needs a chance. He needs help. He needs to be able to pull things together. He needs the medical end of it as well. He's always struggled. I've done my best to get him the help he needs. I finally found a doctor that would put him back on meds to help with his ADHD and his anxiety. Clearly, and he has told me for the last month, they are not working. I haven't fought to get that changed because I was trying to get him into Dawn Farms for recovery. And they won't allow the meds that he was normally on. I know he needs help in every which way, shape, and form. All I'm asking is, I need contact with him too.
This grandmother isn't minimizing Brendan's behavior. She's contextualizing it. She talks about ADHD, anxiety, medication, work, struggle, and most importantly, need. Not just his need for support, but her need to be connected to him. From a legal lens, victim statements usually ask for harsher consequences. This one asks for proximity. That's rare, and it puts pressure on the court to distinguish between accountability and isolation. Notice how the judge listens without interrupting. He lets her finish. That's respect. And also evidence gathering. Engagement question. Do you believe family involvement helps recovery, or sometimes enables repeated behavior? Because the court is weighing that exact risk right now.
Thank you, ma'am.
Yep.
Your Honor, next is his aunt. Oh, sorry, this is going to be family friend. Your Honor, this is Marie Offord.
Zowie
now. Sorry, she's married now.
Hello.
She wanted to say hello, but she's also here to support Mr. Williams.
Hello,
How are you, Your Honor?
I'm doing well.
Excellent news.
State your name again for the record.
Marie Elizabeth Zowie.
Go ahead. What did you want to tell me?
I have met in my recovery journey many people who have the capacity and not the willingness and not the capacity, both ways. In his case, in Brendan's case specifically, he has a lot of people that really love him. He has a lot of support, a lot of assets he can avail himself of. Dawn Farms is also not the only program he has to go to. I cannot recognize my life now from last time I was in front of Your Honor. As we know each other very well. I've been sober for 2.5 years completely. Yes, it is so possible. And someone like this very intelligent young man has every opportunity to do well with the support. I think his family being able to interact with him in the way that they would like to is integral. I don't think I would have been able to without my mother, whom you said some very nice things to as well. His mother, in particular, Nikki, was one of the most important people in my recovery journey. She was there for me on days when I didn't think I would make it through, to be totally honest, and I did. So I know that it can be very difficult, especially from incarceration, to feel like things get better, but they do, I promise. I've been trying to reach out to my contacts in the community to see what I can do for Brendan myself. I know that there's quite a few different places that we believe he can go avail himself of the services there. There's quite a lot in this day and age that is out there if you know about it, if you know how to access it, if you have perhaps a little guidance. Happy to help him get set up with a sponsor if he so chooses. If he doesn't, It doesn't just look like AA, NA. There's many different pathways to sobriety, and they're all legitimate. And I know I struggled for over half my life. Over half. This honorable judge has seen it himself. It is a completely different life, especially with the family starting, things like that. I know he has goals. I know he has the intelligence, and I believe that he has the willingness. I would really like to see him succeed.
Okay.
So happy to see you this way.
Yes, well, thank you. It's great seeing you. I don't often get follow-up from those that
And when I found out that Teresa is going to be his probation officer, I knew exactly how to help too also.
Okay.
So I just like the court to know that we have been, as a collaborative team, really trying to assess the situation and find the best pathway forward. Because I do believe that in this young man's case, perhaps this is his rock bottom. I really hope it is, because it can get worse too. But I think he's got the capacity. And I believe that with the appropriate support, and as long as he remembers the willingness part, we can get there. Okay?
Okay, fantastic.
Thank you, Your
Thank
Honor.
you.
I really appreciate it.
The family friend's testimony is surgical. She doesn't romanticize addiction. She doesn't excuse it. She frames it as a capacity versus willingness problem, and then explains why Brendan has both support and opportunity. What makes this powerful is credibility. She speaks as someone in recovery. She references the judge's memory of her past. This isn't theory. It's lived proof that change is possible. Legally, this matters because judges assess likelihood of compliance. Someone surrounded by active, informed support is statistically more likely to succeed. Audience engagement question: should lived experience carry more weight than professional reports in sentencing decisions? Because here, it clearly does.
Hello, what's your name?
My name's Christy Sarton, and I am Brendan's aunt. And I apologize, I didn't know I was speaking today, so I'm not prepared.
It's all right.
Brendan is a great kid, and I understand that he's 23, but for me, he's still a great kid. He is my nephew, and I love him like he's his son. I, like the rest of my family, have watched Brendan suffer and struggle with his ADHD, with his anxiety, and with the fact that we, as a group, did not teach him how to cope with these things, how to process his feelings, and how to become a stronger individual without relying on substances. Because that, as a family, is what we have all gone through. I believe that Brendan is at a precipice in his life where he has the ability to make great change. He recently found out that he is becoming a father. His girlfriend of many years is 12 weeks pregnant. Brendan did not have his dad in his life. I believe that it has affected the way that he has tried to find security and the way that he has tried to find peacefulness and feeling loved and accepted. Brendan was trying to get sober before these things happened. I had many conversations with him. I watched him get sick because he tried to quit drinking on his own and he couldn't. I have felt at a loss on how to help him. Even when he looked at us and said, I need help and I don't know how to do it, none of us knew how to do it either. I believe that Brendan needs to be held accountable for his actions, as we all do. But I ask that, very respectfully, we look at the implicit need here, the need for help emotionally and mentally, and not just in a punitive way. And I ask that you consider removing the no contact order from my parents. Brendan has been all of our sons, and my mom needs him, just like the rest of our family does. Thank you for giving me time to speak. Thank you.
This testimony introduces the future, and that shifts everything. Pregnancy, fatherhood, legacy. When courts hear about an unborn child, sentencing calculus changes, not because it excuses past behavior, but because it reframes stakes. The aunt doesn't ask for dismissal. She asks for balance, accountability and emotional treatment, punishment and support. This is restorative language in a punitive system, and it forces the judge to decide whether incarceration helps or harms long-term outcomes. Viewer question: should future responsibility, like becoming a parent, influence sentencing? Because many judges say it shouldn't, but in practice it often does.
I will add, Your Honor,
How are you gonna add to
I know.
But go ahead, Ms. Ernie, take your best shot.
All of that was very moving to me. And many of his family members submitted letters on behalf of Mr. Williams during plea negotiations and things like that, which helped us get to this point. So he really does have, as the court can see here, but even more family members that are wanting to support him through this new journey in his sobriety.
Oh. Is that everybody on that side that wanted to say something?
Yes.
All right. And so, ma'am, who's sitting next to you?
This is Brendan's mom.
Okay. That's what I thought was that name.
Yes, sir. She's a little nervous to get up and speak. She loves Brendan very much.
She nervous because of me? No? All right. Okay. She of course doesn't have to say anything. All right. Why don't we come back up? Go ahead, Ms. Perry. Brendan, is there anything you want to tell the court? You understand what a big gift you have?
Yes.
Now, Brendan, is kind of interesting to me as I sit here every day, and a lot of folks come into this court and they have nobody. Right? And I sit there after I sentence them to whatever it is, doesn't matter. They walk out of here or they don't walk out of here, whichever way. And I worry about them because once they leave here, I don't know sort of what they rely upon when things get tough, what they do, right? What it is about you, but for whatever reason, all these people seem to like you. Why is that, Brendan? Do you know? You're gonna shrug your shoulders? You know darn well why. They love you and they care about you, and all they want is the best for you. Right?
This is Judge Simpson at his most direct and most human. He's not speaking as a legal authority here. He's speaking as someone who has watched hundreds of people walk out of this courtroom alone. And he tells Brendan something profound. Having people is a gift. Judges rarely talk about loneliness, but here it becomes central. Support systems aren't guaranteed. They're not rights, they're privileges, and losing them often precedes relapse. Engagement question. Do you think people with strong family support are judged differently in court? Because moments like this suggest the answer is yes.
So after I do this, are you going to be able to sort of work with them to try to get yourself on the right path?
Yes.
Funny thing about me, Brendan, is I remember everything. So when you tell me yes, I'm going to remember that. Okay. On count 3, just a sentence of the court, I'm going to place you on 18 months probation. It's $555 fines and costs, $540 probation oversight fees. Do you have any idea how you're going to get that paid?
Going back to work. Yeah.
Payment plan as arranged by probation. There should be no use of any alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a substance abuse assessment, follow all recommended treatment with status reports to probation. You're to complete a mental health assessment, follow all recommended care, including medication protocol. I'm going to order no assaultive or threatening or intimidating behavior. You're not to possess any weapons, firearms, ammunition, or anything fashioned to be a weapon. You're to maintain employment with proof to probation. I'll place you on a scram tether through community corrections. I'll order 365 days in jail. Credit for 42 that you've served. The balance is suspended with a scram tether placement prior to your release. I'll finish that sentence in a moment, or that sentencing in a moment. I'll go to count 4. 18 months probation, $455 fines and court costs. That will be on a payment plan. Information comply with the terms that I've set forth in count 3. I'll order 93 days in jail. Credit 42. The balance is suspended. On count 6, 18 months probation, $555 fines and costs. That will be swept into the payment plan. Comply with the terms I've set forth in count 3. I'll order 365 days in jail. Credit 42. The balance is suspended on that count. You think I should allow contact?
Yeah.
Why?
Well, my grandma seems like she needs me, and I know I need her. Support is better than none. Like
Pardon?
I said.
What'd you say?
I said support is better than none.
Not sure what that meant. But that last phrase, I got the first one. And then you had 3 impressive women get up here and talk on your behalf. Amazing. Right? You had your grandmother up here talking about you. And this made it clear to me. I understood everything she was saying to me, that she needs you and you need her. Do you think you can do all of this by yourself?
No, probably not.
Probably not?
Yeah, no.
Probably not? I'll let you rephrase that.
Yeah, no.
Do you think you can do this all by yourself?
No.
No, you can't. Right? And so sometimes, like I said to the other young man here, you can be as old as you want to be. You can think you're as much of an adult as you want to be, but you're still just a kid. And later on in life, you know what, Brendan? The great thing about that is there are going to be times when that whole adulting thing becomes real hard that you're going to want to go back to being a kid. Everybody's been there. You want to grow up so fast, but then all of a sudden, that doesn't look great. Okay? That doesn't mean that you can't do the things that you want to do. But, the thing that impressed me about your grandmother is all she really wants to do is she wants to help you. She just wants to guide you and just love you. That's a huge blessing. Right? So sometimes you weren't out here, but I had to apologize to a dad today because I paid attention to mom, because I like moms better. Right? You weren't out here, and I really do like moms. The only thing I may like better than moms are grandmothers. So I just want to point that out, and I'm not saying that out of any disrespect. They're all of a high level. Brandon, I think you can do this. The important thing is sometimes, I'm going to guess, your grandparents going to tell you things you don't want to hear. You're just like any other kid. Do me a favor, when they're telling you that, realize that they're telling you all of that out of love. Take a deep breath and listen. Okay? And in that moment, you may not be able to even understand why they're telling you that. You may just think they're telling you that just to get on your nerves. Right? In those moments, just don't get angry about it. Don't just take it in. You may not at that moment be able to do anything with what they're telling. Right? But then here's the sad thing that happens, Brandon. And why you have to take it in when you have the opportunity. Because one day, you're going to run into the same problem, or you're going to run into a problem that's like, and you're going to be trying to figure out what to do. And sadly, they won't be there with you. And the only thing that you're going to be able to rely upon is what they told you. And it may be that thing that you have to dig up that you said that didn't make any sense at the time. That all of a sudden is going to make a whole lot of sense. Follow me, young man.
Mhm.
You're blessed to have those generations of women helping guide you. Take it in and use it. And I'm going to accede to grandma's wishes. I'm going to allow consensual contact with both John and Donna. Okay? Got that?
This is the decision, and it's conditional trust. The judge grants consensual contact but shifts control entirely to the family. That's critical. Brendan doesn't get automatic access. He gets permission-based access. Legally, this protects everyone. Emotionally, it empowers the victims. And psychologically, it forces Brendan to earn trust daily. This is not leniency. It's responsibility layered with opportunity. Audience question: is conditional trust more effective than strict prohibition? Because this ruling reflects a belief that growth requires both boundaries and connection.
Now, what I mean by consensual contact is if they don't want you around, then you got to leave them alone. You can't have contact with them. All right? It's all on them as to whether or not there's contact. Understood?
Yep.
Okay, don't violate this.
Yep. I won't.
Attorney, anything further?
Nothing further from me, Your Honor. Thank you.
Thank you.
Thank
Good
you.
luck, young man.
What you've just witnessed is not one case. It's an ecosystem. Across this docket, we saw completion, failure, reconsideration, enforcement, compassion, and accountability. We saw what happens when people show up, and when they don't. We saw how money, addiction, family, and honesty intersect inside a system that must make decisions quickly, but live with them forever. Judge Simpson's rulings today reveal a clear philosophy. Punishment alone doesn't fix behavior. Structure without humanity fails. And second chances only matter when someone is willing to meet them halfway. Some defendants walked out free. Some walked out with conditions. Others left with warrants waiting. And one young man left with something rarer than leniency, a court-sanctioned opportunity to rebuild with support. If you found this case as shocking, layered, watched or thought-provoking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns, because these aren't just court cases, they're real lives, unfolding in real time.